Should we start with the Fisher decision, 6-3 for the Supreme Court?
Sure. This is a federal statute, 18 U.S.C. section 1512, subsection C. And so about 300 J6 prosecutions have been brought under that statute. But as Chief Justice Roberts explained, for a bipartisan majority, I mean, justices don't have parties, but I'm talking about the parties of the president who nominated each justice, by a 6-3 ideologically broad spectrum of justices, they explained that, look, you just look at how 1512C came around. You had the Enron scandal. It was a huge, financial markets scandal shortly after the year 2000. And you had one of the big accounting firms, Arthur Andersen, that was auditing Enron because there's all these huge flags that this might be a big scam. And then it looks like, according to the Supreme Court, and of course there have been books and stuff written on this now, there were incriminating documents, Enron documents, that were being systematically destroyed. But all of the sudden, when prosecution was being brought, they realized, well, shoot, under federal law, it is obstruction of justice. It is a huge felony, a felony with many years in prison. If you order someone to go, hide or destroy documents, but if you do it yourself, it actually wasn't against the law. And so prosecutors were trying to have to persuade, a court to find that these executives ordered subordinates to, hey, take that box and burn it and stuff, instead of them going the much more obvious route of having done it themselves, because the latter was not a crime. And so Congress...
Wait, sorry, real quick. I just want to get...
Yes.
So it was a crime to have someone else do it, but it wasn't a crime for you to do it?
Exactly. No one thought to include those words in the statute, because one of the basic principles in our free society is nulla pena sine legis. That's a Latin word saying no penalty without law, meaning something is not a crime unless there's words written in the law books that say it's a crime. That prosecutors can't just make up crimes as they go along if they're targeting someone. It needs to be something that's already on the books. And so Congress passed this law. 1512C was passed, as the Supreme Court says, to plug that hole, just to say, and just to make it clear, if you modify a document, destroy a document, hide a document, or do anything else to keep a document from being available in an official proceeding. And by that official proceeding, they mean courtroom proceedings, not a joint session of Congress. They're talking about courtroom proceedings. That if you do any of those things, you are committing a felony and are liable for up to 20 years in prison. So this was just to plug that hole to make sure that what happened during the Enron prosecution can never happen again. And that is, as the court said, that's the only thing that statute can be used for. And what the government was saying there was that the phrase otherwise referred to any type of anything that might obstruct any form of any official proceeding. And then they say, when Congress gets together, that's an official proceeding. Therefore, all of this, the protest that became a riot, once you're a rioter in that, you're trying to obstruct what's going on, and so that's a violation of 1512. The Supreme Court was coming back saying no, and then they go through all of these rules of statutory interpretation to show that those catch-all words about otherwise in 1512C2, what this whole thing is about, but they say all of it is just to fill in the blanks from 1512C1, where it refers to destroying documents, modifying documents, altering documents, or hiding documents. They said, no, it's by all of these rules of statutory interpretation, that little phrase at the end in 16.2, in C2, just means, and if there's anything we missed in C1, it's covered under C2. For example, the Chief Justice says there's nothing in C1 about fabricating documents. That would be an example of something that's covered under C2. That C1 says you can't modify, destroy, hide, etc. Did we leave out something? Let's put in C2 to say, in case we left out anything, fill in the gap. He said if you were to fabricate a false document during a court proceeding. That would fall under C2. But it all has to be document related, and it all has to be courtroom related. That's what the Supreme Court
What if
said.
you break a window at the U.S. Capitol while they're certifying the election results? Does that count as obstructing obstructing a legal proceeding?
According to what the Supreme Court is saying, no. Now, of course, this doesn't mean that guilty people get off, because breaking a window at the U.S. Capitol, that's a felony. As just like going after a courthouse in Portland, Oregon, and damaging that building. Those are all felonies. We have laws on the books to handle stuff like that. And people who, assault police officers or smash windows in a government building and something like those are crimes, and those people can be charged. You don't need 1512 to do it, because it's already against the law under statutes that clearly cover that kind of criminal conduct.
Correct me if I'm wrong, the story is the government overreached, trying to throw everything they could possibly come up with at these J6ers in order to get as much as they could on them, right? That they stretched the original intent of this law to get something on them. What
the Supreme Court has done is they have said, we're going to tell you exactly what 1512C covers. And now we're remanding that back down. And, both the court in the Fisher case and also every other court dealing with prosecutions where 1512 came up can now reevaluate everything based on what the Supreme Court has now said is the clear and only scope of that law.
Very interesting. And it's interesting that Jackson was sided with the conservatives on that decision as well. She says, men are not subjected to criminal punishment because their conduct offends our patriotic emotions or thwarts a general purpose sought to be effected by specific commands which they have not disobeyed. Very interesting. Let's get back to that another day. I want to get to but that's good news, right? I think that overall that's good news. Everyone's happy with that, or we're happy with that?
It's a huge win for the rule of law that when someone comes after you with the power of the criminal law, which is the power to destroy you. It's the power to imprison you.
Yes.
It's the power potentially even to execute you. It's the power to take away your money and your possessions. I mean, this is, in summary, it is one of the most frightening powers that government has over citizens, is the power of criminal punishment. It is vital to our system of law, or that of any free society, that something is only a crime if the laws adopted by elected lawmakers clearly say it is a crime, so that everyone who's a citizen knows this is the line you can't cross. If you cross this, you can be punished.
Yes.
We're putting these words in these law books so that you have fair notice of what constitutes a crime, so that you can make sure you don't cross that line. That principle is at the foundation of our constitutional system.
Tremendous. Okay, we've got 4 minutes for Chevron, which is one of the biggest, most complicated things ever. But only Ken Klukowski can do it. What did the Supreme Court do?
Well, this was enormous. This is the biggest blow, as I put in the headline, and then the article was so long I didn't actually explain what I meant in depth by this. This is the biggest blow to the power of the administrative state in 80 years, since the advent of the New Deal in the late 1930s and early 1940s. In the year 1984, the Supreme Court handed down its decision in Chevron. It wasn't considered a big deal at the time. People didn't appreciate the implications of it at the time. That says, well, when you have a statute that a federal agency administers, some law from Congress, if there's some sort of gap where the statute is silent, or if there's some sort of ambiguity, unclear wording in the statute, then when the agency enforcing it either fills in that gap with a regulation or passes a regulation to interpret that ambiguity, federal courts, because those agencies have so many experts, they know what they're doing, they're really smart. Federal judges should defer to whatever their agency is, so long as it's reasonable. So if it's crazy, you don't have to do it. But if you at least think it's reasonable, you have to defer to what the agency says the law means, even if the judge thinks it probably means something else. And that has been one of the cornerstones of the power of administrative agencies in the federal government since the year 1984. It has been so harshly criticized by so many conservatives and even some liberals over the years. And what the Supreme Court did on Friday is, at long last, they said no mas. There is no other area of law where we say, when we have two parties before us, and one of them is the government, that one of them, we have to actually defer to what their lawyers say. You know, it's like, wait a second, I'm supposed to be the judge here. The other side is some citizen or some company who says the federal government's breaking the law, and it's you know, it's causing me problems. It's destroying my company, or it's costing me money. And they're like, in that sort of scenario where it's the private citizen against the federal government, why in the world would we in justice ever allow the federal government to then put their thumb on the scale as to what the law is? They said it's the duty, ever since Marbury v. Madison in 1803, it's the duty of federal judges to interpret the law. And if the government wants to make its argument as to what the law means, of course, it's their job to do that. But they're just a lawyer taking one side. We don't give that any deference. We'll listen to the lawyers on both sides, and then we'll just take it for what it's worth. But ultimately, it is the judge who is charged under the Constitution with the authority on, after you're hearing all these arguments, coming up with the interpretation of what the law is, not saying the agency gets to interpret its own laws and then enforce them against American citizens.
Headline: Supreme Court deals biggest blow in 80 years to administrative state. All right, wonderful, wonderful news again. All right, 2 for 2 on those most recent rulings. We've got about 2 minutes. What is going to happen today?
Well, today we're going to have, first of all, the social media censorship laws coming down, the one out of Texas and the one out of Florida. Again, it looked like the laws going after the social media companies for their clear bias and discrimination against conservative viewpoints. You know, it looks like they face an uphill climb in terms of how they, because they're the government as well, how they can do this consistent with the First Amendment. And so the justices will determine whether any of those laws, either of those laws, pass muster. We'll find that out shortly. And then, of course, also the huge, what will be a historic case on presidential immunity, whether, and if so, to what extent, a former president of the United States has immunity from criminal prosecution after his term of office. And we'll see how that plays out in terms of what they say. First of all, whether the answer is yes, and then if so, and it really looked like oral argument, like that answer will be yes, then what is that immunity? Is it, what is the standard? What things are covered under that immunity? And how do courts have to go through those processes and steps before any former president of the United States can be brought to trial? So this is about the constitutional protections, not of one person, not of former President Trump. It is for all U.S. presidents. I mean, this is a rule for the ages to say, what level of protection does a U.S. president have after he leaves office? Because presidents make such difficult decisions, life and death decisions, ones for which there are always people who would want to go after them. And so this is an issue of, what sort of immunity do presidents have to have after they leave office to keep them from being crippled during their time in office in terms of decisions that presidents must make, but that otherwise they might be concerned to make if they know that in a world of 7 billion people, not just here in America, there are people who could criminally come after you for the decisions that you make.